la sesión. Le vamos a dar la palabra a el señor McDonald, su excelencia, para que... ¿No se escucha? We have no translation to English. ¿Sí? ¿Hay? No? Okay. Ready? Great.
The interpreter apologizes. Very well, let us now return to our work. Welcome, then. We will now return to our session, and we are going to give the floor to His Excellency, Mr. McDonald, so that the delegation can respond to the questions that were asked in the second part of the list of questions, and there are also follow-up questions from Ms. Cleveland having to do with the first session with the list of questions. So, without further ado, we will now begin our dialogue on this. Mr. McDonald, you have the floor.
Thank you very much, Mr. Chairperson. Thank you very much for the extra time you provided us. 30 minutes, that was sufficient. We have been able to, to look into the matter with a little bit, we're a little bit more relaxed today, put it that way. There were a lot of questions, and many of those were quite technical. There were a few political questions as well, which we need to see how we will consult our superiors back home in order to have those answers. But with regard to the technical questions, I think that we are in a position to respond in quite some detail. Mr. Jones and Madam Amelia, they will provide us now with the answers, and as we did yesterday, when it is necessary to clarify things or to give you some extra information, I will step in and do this as well. So, with all respect, Mr. Chairman, can I ask you now to pass the floor to Mr. Abu Jones?
Thank you, Mr. Chairman. I will start with the distinguished commissioner with the least questions, and that is distinguished Commissioner Fatala. The question was actually, what's the status of the Child Daycare Act? We would like to inform the Commission that that act is already being sent to the General Assembly, and it's already been taken into consideration. So I think in the coming period we will have that act in function. Article regarding violence violence against children, and in relation to Article 360 and 363 from our penal code, we would like to inform the Commission that, as we already stated in our report, that all form of abuse is against the law, is punishable. So if a child at any way report that he has been mistreated, he has been abused, the case will be investigated, and if necessary, judgment will be passed. That's in one case. But on the other hand, if a neighbor or somebody else reports certain mistreatment of a child, that case will be reported also, and it will be taken into an investigation. So all forms in all conditions will be brought before justice.
I would like to add, there was also a question with regard to corporal punishment at home. You know, the way when you talk about corporal punishment at home, it's a big thing. Corporal punishment at home. Um, as Mr. Jones indicated, if neighbors or if you can see that the kid, the child was abused because you can see bruises and things like that, and neighbors are aware of it, or in school it has been discovered, then such cases certainly, will ask the attention of the judicial authorities, and then action will be taken. Um, in the past, and yeah, I will not say in the past, still it happens that some kind of correctional, I don't know how to put it precisely, but correctional activity, sometimes physically, can be taken by parents towards children, and that is something that is still happening. It is still something that needs to be addressed. It is an issue. It is a matter that needs more consultation with the population, with people who are still doing it to their children. I can tell you that, for instance, I'm coming from a very tough neighborhood, and my mom I was the only child of my mom, and I got some slaps from time to time, and I can tell you that in one point of my life, I thank her for being that strict with me, because if, in the neighborhood, I'm from the ghetto of Suriname, and I think, I can, I'm the only one that came out of it, because she was really strict. Very short lady. I'm a big guy, but I was afraid of her very much. So in some situations, I will, because when you say corporal punishment, it looks like, something really terrible. In some situations, parents, then again, in difficult circumstances, they try to correct their children by using some kinds of physical activities against them. But it is still an issue that needs to be addressed, because I'm not slapping my children, for instance. But I can tell you it works for me, and I'm glad that it happens back then. So we need to take time to see how we can, change that situation it is being changed already, because it is not happening like in the past, but still in certain households, some parents uh, decide or choose to use that kind of punishment in order to keep their children in line. But again, it is something that has the attention of the government and of the authorities, and we are working on it.
Thank you, Ambassador. I would like to. Yesterday, perhaps we were after the session, we were walking back to the hotel, and I was like, "Man, Ambassador, I'm at the Human Rights Council. I was there. I sat there in front of expert, and I was like talking in on behalf of my country." And then I realized how come that I'm here today. What's the reason? And when I go back in history, if my mom wasn't my mom at that time, because my mom she brought me up, and she really shook me sometimes. Hey, you need to learn your lesson. You need to, and you get a slap. But it was never at that level that you need to you go to the hospital, or you need to go to the hospital, or something like that. So the culture in Suriname at that time, now, as the ambassador stated, is changing. But it's still a challenge for us, because the most children in Suriname also, they won't report their parents at the police. But bear in mind, if the police notice any form of abuse, they will they will arrest such person or parents, and there will be matter juris, action taken. And there are several cases in on that remark. Um, so I hope that we answer all the questions from Mr. Fatala. Thank you. let's start with the distinguished Commissioner Rodriguez. Your concern was basically aimed at the human trafficking in person. So the reality in Suriname is that it is a challenge, and we are on it. The government is closely working with different groups, strategic groups to tackle this problem. One of the most important, or two of the most important action that the government took is training for people that need to identify any form of human trafficking, because that's your first step. You need to identify these people, so these victims, so that you could take action. So there are training that had been people had been trained, but most importantly, the government of Suriname works together with the neighboring countries. For example, one of the largest human trafficking case in Suriname was solved with a cooperation with the government of Curacao and the government of Trinidad and Tobago. So there is an interaction. There's actually a tip unit. This is a special unit in the at the um, public prosecutor that focused on human trafficking. So the government is on the case of human trafficking, and we will once again we will win the fight against human trafficking. About the interior, there's other challenge. Suriname in the south, Suriname's border is with Brazil, and there you have a very large part of our rainforest. So it's difficult to get to the backland to actually be there as authority. And we see perhaps that the Brazilians come to Suriname because there is a gold rush in our interior. So at that, in that perspective, you see that you have certain form of human trafficking, and specifically sexual and labor. In that case, to attack that, the government installed the organization called Organizing the Gold Sector. This organization has the tools to go into the interior and identify the different gold, the different places they mine gold, that gold are being mined. And in that case, you have that the gold miner, they need to register. And that's one form that the government need or try to identify human trafficking so that they could take action. I hope I answered the question of the distinguished delegate.
I would like to add, as Mr. Jones said, Suriname has open borders with Guyana, French Guyana, and Brazil. And because of that situation, as he's mentioned as well, the gold mining sector, um, um, people are coming in order to, you know, to work in that sector. And it is in the interior, vast Amazon rainforest, and the government has set up this special unit in order to organize the sector. And I can tell you, it is a big challenge, but because of the open border, we don't have a real control of who is coming in and who is going out and what is happening. But we are doing our best. It is we are trying to, you know, to regulate and to control and to have certain control on the situation as best as possible. But I hope that the committee can, that the committee members can understand that this is a huge challenge, you know, because of the open borders and, of course, lack of facilities in order to control the in and outflow of people who come in to try their luck in the gold mining industry.
distinguished Commissioner Selleck asked a couple of questions. One of the questions is intimidation and censure when it's um, about in the media sector. The government would like to state and actually would like to provide the committee with names of radio stations, private radio stations, so that the committee could take the time to listen to the programs. And when you listen to the programs, you will even ask yourself, I don't think this is censor. Radio stations could say what they want, when they want, and how they want, without limitation. There is no form of limitation of programs on the radio, um, critics against the government or critics against any institute. So we will provide the committee with the radio stations frequency so that you could take the time and just listen, and then the committee will have a certain idea of the situation in Suriname. Intimidation. Actually, the government state there is no formal complaint of intimidation of journalists and activists. And that's correct. Because if an individual person feels that he's intimidated, he needs to go to the authorities because the state doesn't have, it's not fair to the state to be held eligible for complaints from individual. If they're stated, the state will investigate because that's by law obligation from the state. When it's about organization, then we're talking about organization of journalists and media companies. Then when they receive a complaint, they pass it on to the government and the government investigate. But the state would like to mention none of these organizations ever mention any form of intimidation or censure to the government. So the government doesn't really have a basis on what to take action. If that be the case, and we have the information from the organization, then the government will um, take action. Actually, there is a very good cooperation between the organization of journalists with the government, and that's the reason why you have a media board. You know, it isn't in place as yet, but the government accept the idea of a media board done by these organizations. So the question of was also in the question was also mentioned um, who is going to have the seating, what's going to be which party will be seated in the board, because it's the government doesn't want to interfere. The government is in collaboration with these organizations to come to get to a suitable way of staffing the media board. So it's in development with close collaboration with the group. So right about now it's not there yet, but we are getting there, and we're working closely together with these organizations so that it is a product from the organization and it's being facilitated by the government.
I would like to add as well that it's almost custom that journalists have direct contact with ministers and with other authorities. I can speak of my own experiences that is anytime, any time of the day or night, I receive Facebook messages, Twitter invitations, or phone calls from journalists of Suriname. They call me or they contact me directly, and if I have a answer for them or a press information for them, I just provide it. So that is I've been never been instructed by the government not to communicate with journalists or with reporters. And I have the experience as well that many of them, they have the tendency, they have the freedom to contact people in leadership position within the government as freely as possible. Thank you very much.
With regard to the question referring to the Freedom Act, the act that regulate the freedom of getting information held by public bodies, the ambassador already stated that in Suriname it's a custom that actually everybody could just pick up the phone and call the minister, and if he's in the position, they will get the information. That's just the custom in Suriname. Frequently, you will hear the minister on a radio station talking about certain topics. So the information is there. But to make sure and to ensure that the access to this information is further simplified, the, the government introduced two new projects, the e-government project and the e-locat project. That's something like a one-stop window where you can sit at home and you take your laptop and you could access information that's suitable to be published, because in the interest of state security, you can publish all documents, but those documents that are all eligible for to be published will be published. And the two projects that we are implementing right about now are supposed to give that possibility to the public. There was certain concern about the different culture in Suriname and preservation of their religion and and their customs and their culture. Suriname is very unique. It's a very small country, and you have different culture. And the government recognized that, and the government accept that, because that's our way of living. So the government decided to give all these different cultures, different groups, their own national holiday. All. So we have right about now 15 national holidays. 17, excuse me. 17 national holidays. And the 9th of the 10th of October, past 10th of October, you had the Day of the Maroon. And that's the day you could go in town and you see festivities of the Maroon culture. And so you have the Indian, so you have the Japanese, you have the Creole, you have all groups have their own day. That is a way of recognition, but also a way to preserve. At that specific day, you could express and you could show your culture. It's very nice to see that a black person wearing a sari or dressed wear the dress code of Amerindian. These are things you will see in Suriname. Another way of preserving the culture and bringing the culture together is Suriname has one musical band. It's actually a collection of all different cultural instrument there is in the world. It's in one orchestra. So if you get the chance, if the committee has the chance to just Google that and listen to the song and the way the instrument blend together, there will be a very good feeling and indication how we live together in Suriname with our own identity. And when we're talking about food, cuisine, then you will see the most marvelous integration of culture. So that's a simple example of the way Suriname is trying to preserve the culture of the different groups in Suriname. There was a question about recognition of the 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 leaders of the indigenous people. A simple fact that the government recognize these groups is that the salary of these people, these leaders, are being paid by the government while they are being elected by the custom of their group. So that's a form of recognition of the government of these people, these leaders, and their decisions. I hope with that I answer all the questions asked by the distinguished Commissioner Selig. I'm going to leave the question of the distinguished delegate Commissioner Cleveland for the last. So I will enter to the I will try to answer the question from distinguished Commissioner Fasal from the distinguished delegate in front of me. Bardelashvili. Bardelashvili. My pardon. There are numerous questions. One of the the important thing is that in the case of detention of minor, we already brought by law extended the age to from 10 to 12. So we are in the scope of the international expectations. There was the commission needs clarification on the, the length of stay in detention. So it's I will try to explain the way it's been done in Suriname. When uh, when a certain person is being accused of a certain crime, he's taken into arrest by the police, and the inspector decide on the grounds of information and proof if there is enough proof to detain this person. But the maximum length that the inspector could decide if someone stays in detention is 7 days. But before that, before the 7 day elapse, he that the the accused, the person that's been accused, need to go appear before a prosecutor. So the custom of Suriname is that in 3 days' time, 3 days or 4 days, the person is brought before a prosecutor. Then the prosecutor have the, by law, have the power to imprison this person for maximum 14 days. But the custom is Suriname that in 7 days, so the, the 3 days and 4 more days, the person needs to come before an investigative judge. And at that moment, if there is enough proof, the investigative judge could extend the length of the detention for 30 days. And that's the reason why you have actually 34, 43 days. And so it depends on which moment you count it up. So it's 3 days, then 4 days, then 30 days. After that, if there is enough proof, you go to the case is brought before a court. But if they're still in an investigation phase, the investigation judge could extend the detention for a certain period, and that's what we mentioned in our report. When the case is brought before a court, the length of which the case must be a judgment must be have taken place, it depends on. A certain time is fast, and other time is longer. But at the moment it extend the international request of prompt of due process, you have that result in minimization of the, 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 the sanction that could be opposed. Perhaps if the prosecutor asks the judge to sentence you to 5 years imprisonment, the judge surely will take in account the period you stayed in detention. That will be taken, that will be subtracted, and for the long process that you had to be wait before you get a judgment, you have that the judge will exclude a certain amount of some months, some a year or two. It depends on the judge, the circumstances, and yeah. So it depends on when you're brought before the court and the decision. I hope that's clear enough. At the moment you're being arrested, the arresting officer is supposed to read you your Miranda rights. At that moment, you're supposed to know you're eligible to say nothing. You don't need to say anything, and also you have the right for a lawyer. So, if you say yes at that moment, before you go and give a statement, you could ask for a lawyer to be present, and that will be granted. And you're not obligated to give a statement if your lawyer isn't present or anything like that. So I hope that explained the procedure. And also, in certain cases, you have, and actually I'm going to take a question of Honorable Commissioner Cleveland in answering your question also. We'll take them together. One of the most important thing is there's an 8-day period where a detainee could be withheld the access to a lawyer. That's only in certain cases. Perhaps if we're talking about drug trafficking, we know that's international is a very complex or mostly complex cases. So in that situation, the prosecutor could decide that the access to a lawyer in the interest of the case could be denied. But the law states that that can be longer than 8 days. No, it cannot be longer than 8 days. So and it's the same case it's the same situation with terrorism. Anybody accused of terrorism, it depends on the situation, you could be denied the access to a lawyer, but not for longer than 8 days. About Opa Duli, that's a correction center for children. Actually, the government of Suriname, minors who did something wrong, the government we don't see them as to be a criminal. We see them more in the scope of someone who did something that isn't acceptable to the community. So these children, children are taken out of society and put in a certain environment where they are actually obligated to go to school. They has to go to school, and they are getting certain programs, treatment, so that they could be made ready to go back into society and live a normal life. And Opaduli is actually until you're 18, and these children could never be in contact with criminal, the older criminals, because we all know what the influence could be, and it's only fair that these children have the opportunity after a certain period to continue their life normally. So that's the idea, that's the background why the government put up this institute. And in no other facility you have the juvenile comes in contact with adults. So the only institute where you have where juvenile are being locked up is the the Opaduli Correction Center.
I would like to add with regard to OPA Duli Correction Center. Frankly, I have not been able to go and see it. So I'm wondering if they have detained cells and how have you been there?
Yes, yes.
Okay, if you can tell the commission a little bit, because I would like to know as well, because I have not go there, but I've heard that it is because before OPA Duli, boys and I think girls too, but children were locked up with adults, and that was a big concern of the government. So they created this institution, this center, and maybe you can tell the commission a little bit how how the system works. Are they locked up in cells for how many hours? Are they getting education? Are they being schooled? How does it works in practice?
Yes. I would love to do that, Ambassador. Um, when a child is being accused of certain crime, he's been arrested by the police. At that same moment, he's been transferred to Opaduli. There he's been accepted. Then he will be accepted, and the procedure will start. And the procedure is actually simple. You get your cell, and it's not actually a cell. It has bars, but it's comfortable. And you share a cell with two or three other juveniles. In the same complex, because it's one big complex, in the same complex you have school, you have a basketball field, you have actually everything you would have done, you would need as a child to to pass your childhood. So the only time you're gonna go into your cell is if you're like in the evening when you need to go to bed, or if you really, really shown behavior that ain't suitable for the other juveniles. So then you will, for a short time, you will be sent to a part um, 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 room with also limited facilities, but it's it's far better than a detention center. You have television, you have games, you have the possibility to stay in touch with the world. In the same complex, you have perhaps juvenile court. So you don't leave the compound. Everything is done on the same compound. You have the juvenile court, you have the prosecutor that's specialized in juvenile cases is also there. So the moment you come into the juvenile center the next day. It depends on how late you come in, because if you come in the morning, in the afternoon you're going to see the prosecutor right away. Or the next day you'll go to see the prosecutor. Depends on if you come in the night. And when at that moment you're constantly in contact with the parents. The parents could bring anything for you. They could bring food. They could bring even clothes every day. So that's actually, in a nutshell, the way it functions. It works there. And then I hope I have answered all your questions. I will continue with questions from distinguished Commissioner Cleveland. One of the question is the influence of the government in the process of prosecution at the prosecution office. The government would like to state, in other countries you have like the head of the prosecution is being elected or is being appointed by the political leaders, or it depends on. In Suriname, that isn't the case. If you have, and perhaps that's the case now, if you have a certain government in power and you have a certain prosecutor, when that government leaves office, that prosecutor keep on going. So the exchange according to the political influence, he doesn't have that. Actually, in our constitution state that that the, the influence that I will, yeah, article 1 minute. I had that article. Oh yeah. Article 10 on Article 45 of the Constitution state that the only body that's capable of deciding who is going to be prosecuted and who's not going to be prosecuted is the prosecutor office, not the government. Nobody. There's one exception, and that is if the prosecution decide not to follow up a certain case, the victim could address the 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 1 moment could address the high court. I just needed to find the right English word. Could address the high court with a request that they ask of, actually not even ask, they give a ruling that the prosecutor need to investigate the request from the victim. So that is a certain way of that's the way it's been done, but it's strictly forbidden for the government to influence the decision made by the the public prosecutor. Um, there was also a question about, okay, the amnesty law is being adopted by the parliament, but it's been approved by the president. I would like to clarify that in Suriname there is a custom. It's not it's not our custom to that when the General Assembly adopted a law that the president put it aside. It's not a custom. It has never been happened in Suriname. That's not the way we are accustomed in Suriname. The utmost respect from the government, from the president the to the General Assembly is to accept the law taken by the government, by the General Assembly, actually the representative of the community. So when the law is being sent to the president signed it, and then it's been published. And when it's been signed and published, then it would be enforced. But that's a custom. That's the way it's been done in Suriname. So in that scope, you need to look at the amnesty law. It's been respectfully approved by the parliament, adopted by parliament, and the president accept that and sign it and publish it. The ambassador?
If I may, just for clarification, if a law has been passed by the parliament, it will go to the president, and it cannot be overruled by the president. It goes to the president just for his signature and the publication. But it has not happened, as was stated, that a law that is passed by the parliament can go to the president and the president can overrule it. So that is not the case. It goes to the president for his signature. As a president, he needs to sign it, and then it needs to be published. And when the law is published, then it immediately goes into force.
Information according to the marijuana case, and that people who are willing to testify that they are being threatened. That information is new, but I could guarantee you, and that's what the public prosecutor also stated in his remark or his request for people who want to testify to come forward. There is anytime you feel that you have a certain fear and you make contact with the prosecutor office, they will provide you protection. So I don't know the basis upon or why there are reports that say people are afraid to come forward. Actually, there is his name. There's a certain person who stated he could get a group of people who want to provide their testimony to come and do that. So the public prosecutor, did give him the opportunity to do so, but until the date of today, we didn't have any people come and saying, you know what, I want to give my testimony upon the situation of the marijuana case. There was also a question about the insurance that the committee wants, that people who are elected to become, or people who are going to become judges, that they are capable of doing the job. So Suriname has a certain way of recruiting judges. When you are recruited according to normal procedure, you need to have a training of 5 years before you could become a judge. And this training is being done by the Surinamese experts with close cooperation with the expert from the Netherlands. So the insurance that the quality of these judges are at the highest is being granted by the 5 years of the 5 years course you need to follow, and also the way it's been done. It's been done with close cooperation with the Netherlands. And there's also another way of recruiting judges. That is the way by the Rio opleiding, the Rio training. That's a training that's shorter than the 5 years. It's 2 years, but that's only the people who could follow that training are lawyers that has been at least 15 years practicing law. So the experience is very important to able to be capable of following the Rio uplading from 2 years. So I hope I have answered all the question of the distinguished Commissioner Cleveland, and the ambassador would like to.
Just to add, just for clarification with regard how judges are being recruited. After your legal training at the university, everybody who has been graduated as the law faculty at the university. We are all lawyers here. But then you need to go and do an extra training to become a judge for 5 years. That's separate, and as was said, if you have 15 years of legal practice experience, then there is a separate procedure for those people. But in general, and in the past, it was not like that. There was another system, but it has been structured lately, not lately, I think it is now for the last 10, 12 years, that there is a specific training of 5 years in order to train judges before they can be appointed in that capacity. Sorry, what is it? Sorry, Mr. Chairperson, and with that, we have tried to provide answers on the questions that have been, the queries that has been posed to us. As was said yesterday, we have all the questions still, and we will review them again. And in case we have missed certain queries, we will respond. We will make use of the 48 hours window in order to provide the committee with updated information and with, so that the committee can have a full picture of the situation in Suriname. Thank you very much.
Muchas gracias a usted.
Thank you very much. Thank you, Ambassador. We will now proceed and see whether other colleagues have asked for the floor with follow-up questions. I see that they have. We don't have a great deal of time, but we will take advantage of that time that we have left as well as we can. The first speaker on my list is Mr. Rodriguez Recia. I give him the floor, sir. Thank you, Chairman, and I thank the delegation for the responses to the questions that I asked and that the other colleagues have asked as well. I believe that on a point of methodology, I would begin with the following. Having heard the responses, I believe that many of them did not satisfy or fully respond to the questions that we made, and me in particular. I do understand the last thing you said, which is that within 48 hours you will be sending along written responses. In those written responses, I would like for your focus to include a broadening and comprehensive focus on preventative measures, because some of the responses, for example, on violence against children, mistreatment, abuse, were responses, they're anecdotes, and they're ex post facto as well. I understand the concern of the state in the issue of fighting violence or child abuse in all possible area, but much of this is ex post facto. It's reactive. It's not preventative. So I would like to have responses that look more at the idea of a preventative public policy for combating child abuse or violence against children. Again, a preventative focus. The same with trafficking in persons. It's a very complex issue. We understand the issue of your open borders and the jungle and the work that you are doing with other countries, neighboring countries. I'm not going to repeat it now, but my concerns and my questions on statistics and disaggregated information and the support for the victims of trafficking, the issue of the private sector companies and weapons, and not just in a registry in the Ministry for Gold Mining, but also more comprehensive and overarching look at prevention and the structural causes that give rise to trafficking in persons. Turning to access to information, I would like to know what some more objective criteria might be when it comes to the restriction of certain documents that the state might believe to be confidential. But what is the legal certainty behind these choices, and why not look at the possibility of a more open law regarding freedom of access to information, as other countries in Latin America have? Mexico, Honduras, they have solid legislation on access to information. I and Mr. Alex asked about the protection of tribal groups and indigenous peoples, and the response from the state provoked great interest on my part in the recognition of national festivals and music. However, our questions were looked at the consolidation of collective rights. And what I was talking about had to do with recognition of territory and lands for the traditional groups as part of their life, really. The link between their life and their territorial lands. And the recognition of the culture is all fine and well, but the rulings in the Maiwana and Saramacca cases, the rulings from the court are very much aimed at this, and not just the financial redress. And a comment, if I might, on the adoption of laws and whether they're vetoed or not by the executive branch. Really, we don't get involved in the domestic process for the enactment of legislation, but rather the state's international responsibilities to the committee. And it's not that it's not that we don't care about the domestic roles of different branches, but rather the whole broad idea. For example, amnesty. The amnesty law here is a matter of the state having a responsibility to their international obligations, and that's the perspective that we take when we look at that. Thank you very much. Thank you very much. Thank you, Mr. Rodriguez-Recia. For the delegation to learn perfectly the name of the expert, we will now give the floor to Mr. Vardelashvili.
Thank you very much, Chairman. And I'm grateful for the information provided by the distinguished delegation. I assume that there is some information which will be provided in writing during the next 48 hours, particularly in relation to the psychiatric hospitals, about the procedures and guarantees there, or the plans regarding the police detention centers, as well as the plans and measures in relation to the dissemination of information on the covenant and on the concluding observations and so on. Let me also use this opportunity and add one more question, which you could also, of course, provide later on answer, is about the statistical information. You provided the stats about the number of detainees per detention center, although the committee also requested desegregated data about the gender, ethnic background, age, and so on and so forth. I understand probably that you don't have this information, and I would be interested to learn if the country is planning to have in future such information or such statistical data. Now, let me clarify some points. You mentioned that you've raised up the age limit to 12 years old, criminal responsibility age on 12 years, which is in itself a positive step. But I was also interested about the time limits for the juveniles, and I understood from your responses that you bring juveniles to this Opaduli center. So does it mean that every juvenile, whenever he or she is detained, immediately brought to the center from every region of the country? That's how it happens. And they appear in front of the prosecutor, but they do not appear in front of the judge. Is it correct? And if it is correct, then when they will appear in front the judge? When is the requirement by the law? What sort of requirement by the law do you have? And the same goes to the adults as well. You mentioned 3-4 days for the prosecutor to make a decision, and after that it goes to the judge. I just wanted to clarify. So after 3 or 4 days, the detained individual may appear in front of the judge. Okay, I'm sorry, yeah, must appear in front of the judge, but it will be after the prosecutor approves the detention. Okay, that's what I understood too. And the final question was on incommunicado detention. You mentioned the prosecutor can allow incommunicado detention, so it's not really a judge who is involved in that decision, but the prosecutor. It may happen from the very beginning of the detention. That was correct, right? Thank you very much. I just wanted to be sure that I understood the information correctly. Obviously, I'm not assessing the answers, not to prejudge an outcome, but obviously there are concerns in that regard. Thank you.
Of course. Thank you very much, Mr. Bardellashvili. Now I pass the floor to Ms. Cleveland.
Thank you, Mr. Chairperson, and I would again like to thank the delegation for the responses that they have provided the committee. I also had a few specific follow-up questions regarding the issues of the criminal process along the lines of my colleague, Mr. Bardellashvili. And if you could either clarify these now or later in writing, I would be very grateful. So, am I correct, for example, that the law does not require that a person be brought before a court until 7 days after the arrest? Or if you could clarify for us when an individual who's detained for criminal proceedings must be first brought before a court. That would be helpful. Likewise, when does the law require that a criminal defendant must be informed of the charges against them? With respect to incommunicado detention, I had the same question about the prosecutor. I would also ask if you could clarify if there's any further legal standard that is applied that elaborates on when it is in the interest of an ongoing investigation to subject someone to incommunicado detention and deny them to counsel. You mentioned drug trafficking and terrorism cases as being cases where the complexity might warrant it, but is there any legal standard other than it being in the interest of an ongoing investigation that is applied in this context? And then finally, I had asked questions about the adequacy of access to free legal aid in both civil and criminal cases, and any information you could provide on that we would greatly appreciate. Thank you.
Thank you very much, Ms. Cleveland. I have 2 more members in my list. The first one is Mr. Setulsing. Mr. Setulsing, you have the floor, sir.
Thank you, Chairman. I have one brief follow-up question concerning the amnesty law. In the context of the amnesty law and the suspension of the trial of the 25 accused, one of them, we are informed, Mr. Ritfield, asked that his trial should continue. And it appears that the Court of Justice ordered the resumption of the trial. So in June 2014, so we would be grateful if you could provide information about the state of the proceedings concerning the trial of Mr. Ritfield, whether the trial continued, whether it was not resumed, or if it was over, or if it is over, what was the outcome. Similarly, we have information that the victims in that case, where the amnesty was granted or by the National Assembly, that the relatives of the victims have filed a case before the Inter-American Commission on Human Rights. Could you, if not today, maybe later, inform us about what has happened to that case before the Inter-American Commission? So I thank you in advance for your replies.
Thank you very much, Mr. Setulsing. And now I pass the floor to Mr. Yuval Shani, you have the floor, sir.
Thank you, Mr. Chair. This is the first time I'm taking the floor in this dialogue, so although it's quite late, it's better late than never to congratulate the delegation. Almost upon its departure. I wanted to touch the point already also made by Mr. Varzilashvili and Madam Cleveland on the timelines for detention. I wanted to draw the delegation's attention to our general comment 35 that was adopted last year, and specifically addresses in paragraph 32 and 33 what is in the view of the committee the correct interpretation of Article 9 of the Covenant. So according to that general comment, 48 hours is ordinarily sufficient to transport the individual and to prepare for the judicial hearing. Any delay longer than 48 hours must remain absolutely exceptional and be justified under the circumstances. So so I would invite the delegation now, or even within the 48 hours that you have, to submit your to also allude to that standard, and how do you deem the law in Suriname to be compatible with that standard. I would also note that in paragraph 32, the general comment explicitly states that the public prosecutor cannot be considered an officer exercising judicial power under paragraph 3 of Article 9. So while I appreciate the importance of a prosecutor interviewing the detainee within 3 days, if I understood correctly, from the time of detention, for the purposes of the standard that we have laid down, this would not suffice. So I would invite the delegation's reflection upon this. And the second point which I wanted to raise has to do, it was not mentioned in the list of issues directly, but I think it is pertinent to our evaluation of the situation, and this is the defamation law in Suriname. I understand that on the books, the penalties in Suriname for acts of defamation are quite harsh, and they involve prison sentences for up to 7 years in some cases. And also when defamation is targeted against public officials, this may also entail the loss of certain civil rights, for instance, the ability to participate in certain professions. I understand journalism. Now, I did read that the government has expressed an interest in or expressed willingness to review its defamation legislation and to perhaps align it with other countries in the region, which have gone to decriminalize and significantly lower or significantly lower penalties associated with defamation. So any clarification that you could provide us in this respect would be useful. I would also draw your attention in this regard to our general comment 34, which takes the position that states should consider decriminalizing defamation laws, and that they should not, under any circumstances, use imprisonment as a sanction for defamation. Thank you very much.
Thank you very much, Mr. Shani. Now I pass the floor to the delegation.
Thank you very much, Chairperson. Can I ask Mr. Abu Jones to elaborate on the technical questions? Thank you.
Thank you, Chair. When we're talking about the situation in the police lockups, then we need to state that the government is actually taking major steps. One of the most important steps is renovation of all the police stations, and in total 35 police stations with a lockup. All are being renovated. Actually, there are only 4 that needs to be renovated right about now. The rest are already renovated. So the living condition and the living situation is up to the standards. About the case of Rietveld and the case that is pending at the Inter-American Commission, the case of Rietveld is ongoing. So I don't know precisely when is the next date he's supposed to um, 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 be in front of the judge. I don't know precisely, but his case is still pending. About the case by the Inter-American Commission, that's also pending. So the state is waiting on the invitation of the commission to take further steps. About when a detainee, when a suspect is being arrested, at that moment, you need to read him his rights. Not later than that, at that moment. Um, if a suspect, one of the rights are you have a right to access to a lawyer. The moment you state that you can pay for a lawyer, the state gives you a lawyer. We have a certain system in Suriname that one moment, the right word. Oh, that's a very difficult word to translate, but I'll try to explain it. You have a system that every lawyer that registered at the organization that is eligible to appoint a free lawyer to a detainee, they have a system that every week you have other lawyer on standby. So if dating comes in and detainee asks for a lawyer, there's a certain lawyer in the first week of the month that any police station could call, and they will get that lawyer to come and represent the, the that person. So that's the system. We call it in Suriname piketwacht. Um, I have the case of Rietveld. 48 hours. That's the question to promptly bring someone in front of a court. The government need to state that the situation in Suriname, the reality of Suriname is that right about now we have only 19 judges. For the whole country, we only have 19 judges. There was a certain moment that it was only 12 judges. In the past 4 or 5 years, we tried to bring that up to the certain amount, 19. From out the situation, the constitution gives us the possibility to bring it up to 34. But that process is very slow. And that's not because of the unwillingness of the government, but if you want judges, you need to have people who want to become judges. And one of the main issue was the salary of a judge. Now we adopted a new regulation that the salary of a judge is being pulled up to the same level as the salary of a minister. So that's attractive for candidates to apply to become a judge. So that's the challenge that the country needs to deal with, and we are dealing with it on certain matter. It's a very difficult and we're talking about your judicial system. So you can't just because of the interest of more judges, you just take people in. You need to guarantee that the people that you're going to put on the training and later appoint to become a judge has to be of a certain standard. They have to be of a certain um, um, how you say it? One moment. A certain integrity. So you can't just for the sake of making the number become larger that you just so that's the challenge that we are facing, but be sure that we will get there. So that has that had been said, the difficulty to bring someone in 48 hours before a judge is right about now something Suriname. It's a challenge for us to apply to that specific way, specific period. But what Suriname does is actually making sure that in any cases that in the time of 7 days you are becoming in front of an individual judge, an investigative judge. So I hope that that's a clarification on the question. Other question was about the right of land for the indigenous people and also the Maroons, but also the cases brought before the Inter-American Commission. The Suriname reality is the Suriname reality. And the Suriname reality is this. You have the indigenous people and the Maroons are certain part of the community. And the groups that actually lives in the interior, these groups are small groups. Because the most of the Maroon, they are in the coastal area, in the town, the big cities. So these people in the interior, they have rights. But the question and the challenge for Suriname is Suriname rely on the natural resources in this part of the country, in that part of the country. The question is to make sure that a larger amount of the population get the necessary ontwikkeling, the necessary development, we rely on these natural resources. So how does Suriname combat the situation? What does Suriname say? The government said, we have, as government and the constitution said, everything that's in the ground belongs to everybody in Suriname. You could extract it on behalf of the society and on behalf of development of the country. But the government of Suriname makes sure that when these actions are taken, they always consult the, the, the head of the population in the different communities. And that resulted in certain cases where you have that the government wanted to explore certain activities, but because of the findings of these leaders of the indigenous people, the government actually put that project aside. One of the projects is the Tapajai project, and that's the Tapajai project is one of the important project to provide more energy, electricity for Suriname. So that's a clear way of stating that we does recognize the challenge and we are looking to work together with this community to challenge the situation. And one of the most important thing is that the government is in dialogue with these communities. The government is in, we had 2 years ago, we had a major conference with these groups in the interior where we asked them about what do you like, how do you see it, let's work together to come to a solution. And that process is still ongoing. And one of the main issue of that conference was we would like a presidential commissioner. And that's what they got. They got a president commissioner that is a sort of a liaison between the people and the government. So I hope that with this information, we try to answer all the questions, and those questions that we need to answer were unanswered will be submitted. I would like to pass on to the ambassador.
Thank you very much. I pass the floor to the distinguished delegation for the closing remarks.
Thank you very much, Chairperson. It's already 1 o'clock or it's past 1. I wanted to say something on defamation, but we don't have the time to. But this was an important question, and I really like to say something about it, but we don't have the time. First of all, let me thank the Commission for the constructive discussion. That's what we are here, and that's what we wanted. That's what we expected as well. With regard to the statistical information, of course, we will pass this information on to our superiors back home, and with a specific, not instructions, but the specific request to specify the data, so it's like that was asked to us, age, gender, ethnicity, to make sure that we provided that information as requested by the committee. Um, I don't have a lot to say. I want to ask the chairperson something on the 48 hours response. Since today is Thursday, we are leaving tomorrow. I'm going back to New York, and the rest of the delegation will arrive in Suriname on Saturday. They are going to Netherlands and need to spend the night there, and the next day they will be traveling to to Suriname, and that means that 48 hours is Saturday midday. I would like to know, Mr. Chairperson, is if there is, and Saturday is also a weekend, so a day in a weekend. And I would like to know if it is, if we need to be strict with between the 48 hours, or that there is some wiggle room to bring it to Monday. I just respectfully want to ask that because of, again, challenges of traveling. We need to travel really far. But again, I would like to, I think that this is going to be my last presentation in front of the commission, since I think I've been present in all treaty bodies, in all of them, even the UPR. And it was a very good experience for myself. I don't know if this will be my last one, but it can be, because it's time to pass things over to the younger generation. And I think that my colleagues, Abu and Amina, that they've learned a lot. As lawyers, human rights lawyers, you learn a lot when you come to this is the highest what you have. And I thank the committee members again for the respectful and thoughtful, their criticalness, and the way they have treat us. Again, Chairperson, thank you very much.
Muchas gracias a usted.
I thank you. Thank you, Ambassador.
Yesterday, we communicated back home with our superiors, our leaders back home, and we asked them, or they instructed us to, because we have been talking so much about the culture, the situation in Suriname, and we have realized that it can be maybe a little bit strange or hard to understand and to grab. Maybe we are not fluent enough. We will send a formal and official invitation to the committee to send or to invite them to Suriname, so that they can see on the ground what we have been trying to explain here. It is it's not that easy all the time. And every commission I went to, I need to do the same thing. And every time I had the same response. So we will send a formal, I don't know if it will come from New York or from the government directly, from the Ministry of Foreign Affairs or Justice, to invite the committee or members of the committee for an on-site visit in order to just experience Suriname. Thank you very much.
Thank you very much. Quiero agradecer mucho a la
I'd like to thank the delegation for the dialogue that we've had. I'd like to inform you that the deadline that we have for sending in information will be 1 p.m. on Monday, and so there is no problem for you to send the information in on Monday. The 48 hours cover working days, and so you can send this information for 1 p.m. on Monday. Unfortunately, I don't have the time left to close the session as I'd like. However, I would like to say that perhaps the state won't be surprised when we express some concerns surrounding the amnesty law.
and the difficulties that this law represents for us in terms of the full enjoyment of civil and political rights. And this not only within the country review, but also in terms of the fulfillment of individual obligations undertaken in 1983, and that are still not fully fulfilled. The same is true with the rights of indigenous peoples. We really have been struck by various issues that are normatively incompatible according to Article 2, where the state party must adopt all necessary measures, including legislative measures, in order to ensure full implementation of the covenant. And perhaps it would very much assist you to look at General Comments 32 and 35 of this Human Rights Committee to assist you in fulfilling these obligations. As this is a public session, I'd like to state that I truly do not feel that we need some kind of corporal punishment, some kind of punishment to have success in life. There are many, many people who have not had to suffer slaps or any other type of treatment who would still thank our parents for the way that they have raised us. This is a cultural issue, and we are sure that this dialogue has assisted us in moving forward toward the enjoyment of human rights. Thank you very much to the delegation and to the interpreters for the extra time that they have given us, and with that I can adjourn the session.